Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to discuss the lawsuit filed by the state of Illinois and the city of Chicago to block yet another unlawful deployment of the National Guard within the United States. This time, the state of Illinois and city of Chicago have acquired an order that now prevents the deployment of the Illinois National Guard or any other National Guard unit within the state of Illinois and the city of Chicago. This is similar to the episodes where we covered unlawful deployments in LA, episode 45, Portland, episode 47, DC, and another recent episode. On October 6, 2025, Illinois and Chicago filed suit against the administration of Donald Executive Overreach Trump in the U.S. District Court for the Northern District of Illinois in the Eastern Division. On October 9th, 2025, U.S. District Judge April Perry issued a temporary restraining order, one preventing the Trump administration from federalizing and deploying the National Guard of the United States within Illinois. The order is set to expire on October 23rd, 2025 at 11:59 p.m. A hearing is currently set by the order to occur on October 22nd, 2025 at 9 a.m. to determine whether this order shall be extended for 14 additional days. On October 11th, 2025, after appeal from the Trump administration, the U.S. Court of Appeals for the Seventh Circuit narrowed the injunction. The narrowed order denies the administration's request to deploy the National Guard within the state of Illinois, city of Chicago, which trial court orders TRO currently prevents. Basically, here, appellate court order affirmed that order denying the deployment. However, this appellate order permits the administration to federalize members of the National Guard. Basically, they can federalize, have them on standby on bases, and if the prevention order preventing deployment within the state of Illinois and Chicago is lifted, they could hypothetically then move them quicker. Don't see that happening, however, unless SCOTUS touches it, maybe gets on the shadow docket. Anyways, Illinois and Chicago filed a 69-page lawsuit alleging the Trump administration's effort to federalize National Guard troops, first Illinois Guard, then Texas Guard for deployment into Illinois, violates basic constitutional and statutory limits. The suit centers on three pillars. 1. 10 United States Code, section 12406. This is what's been coming up in all the other cases, which essentially states that the president can only call into federal service state National Guard units if there's 1, an invasion, 2, rebellion, or 3, the president is unable to execute the laws with regular forces. The plaintiffs, Illinois and Chicago, argue that none of these predicates exist in Illinois to authorize the president to federalize and deploy any National Guard units within Chicago or within Illinois. Protests at an ICE processing facility like the one in Broadview, just outside of Chicago, were small, mostly peaceful, and handled by local and state police. Federal government is still enforcing the law, indeed boasting about arrests that it is making in Chicago and within other parts of Illinois. 2, second pillar is the Posse Comitatus Act and Department of Defense limits. Once National Guard members are federalized under Title 10, they become part of the regular U.S. military for legal purposes. The Posse Comitatus Act prohibits the U.S. military from performing domestic law enforcement functions like arrests, searches and seizures, or crowd control unless Congress clearly authorizes it. The lawsuit says that the administration's state admissions, facility protection, access control, crowd control would in fact violate the Posse Comitatus Act. Third pillar, federalism and separation of powers, 10th Amendment issues. Chicago, and Illinois argue that the Trump administration's move tramples the state's 10th Amendment general policing powers and commandeers Illinois to abandon its own state laws like the Trust Way Forward Act and tries to use troops as a political cudgel in disfavored sanctuary jurisdictions, raising 10th Amendment, equal sovereignty, and separation of powers problems. The bottom line, like the other jurisdictions we've discussed, this is unlawful, unconstitutional, political theater, utilizing members of the National Guard, and stretching the text of congressional statutes way beyond reason and possibility. Excuse me. As discussed, the temporary restraining order, as narrowed by the appellate court, prevents any National Guard from being deployed within Illinois and the city of Chicago, at least until October 23rd, 2025, as of the time of this recording. For those that may not know, a TRO, or temporary restraining order, is an extraordinary form of relief for a court to grant, especially to be mostly upheld on appeal. Under the applicable rules of civil procedure and case law, courts don't typically issue TROs unless the plaintiffs in a lawsuit show that they are likely to succeed or that there are serious questions on the merits and a risk of irreparable harm to the plaintiffs unless a TRO is granted while the case is pending. In other words, a TRO being issued, as it was in this case, is an early signal that the court believes that the 10 United States Code, Section 12406, predicates, as previously mentioned, invasion, rebellion, inability to execute federal law, likely are not satisfied by the current situation on the ground in Illinois and in Chicago, and that using federalized National Guard troops for domestic policing within Illinois and Chicago would likely violate the Posse Comitatus Act in addition to the 10th Amendment of the U.S. Constitution. Yeah, no shit. The appellate court's narrowed order still prohibits the deployment of troops within Illinois and Chicago at this current time. Keep in mind that these orders are procedural and temporary. I believe the narrowed order preserves some flexibility for the administration, but still prevents the deployment of troops during this time, during this initial stage of the lawsuit. The government can do things like stage troops on bases, as previously discussed, and basically keep the troops on a base, the ones that have already been activated, brought in from Texas, whatever. Hopefully they'll just be sent back to Texas, because I don't see any grounds where any deployment within Illinois at this time is even remotely lawful. Keep in mind, this episode is not about abstract civics. This is yet another live test of whether or not a president can sidestep civilian policing by declaring that routine protests constitute an emergency. So the president can drop soldiers into domestic law enforcement roles, despite statutes and 2 centuries of tradition of resisting exactly what this current president and administration is attempting to do within Illinois, Chicago, Portland, LA, and other American jurisdictions. Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.